All right, I am going to spend a little bit of time just laying out some of the new rules that were just amended and talking about them. We have the new rules of civil procedure that relate to ESI, the electronically stored information, which is very important, especially in this district where a lot of this stuff has to be digitized, at least at the federal level, and filed. These were effective December 1st, 2006. Already you should realize, and I can't believe that some lawyers wouldn't know this, they want to buy programs called Evidence Eliminator. And if you didn't think that that might be a problem, if in a court you said, oh, we just used Evidence Eliminator and ran it through here before that, it's probably a big issue and a concern. So again, things that you need to be talking to your client about, which we'll discuss in a moment. But with respect to the rules, the rules that have been amended, the goal was to lower burden, cost, uncertainty, and most importantly, imbalance. Everyone is sort of unsure. Some people are still with paper, some are with electronic documents, some don't understand a lot of what is involved. A lot of information can be hidden, that sort of thing. So the rules are at least designed, and they will probably be amended again, but at least this first round has to do with making it faster, less expensive, and engage in a better collection and preservation of e-data. Okay, why is it so different? As been pointed out, just the sheer volume of information makes it so that it's very easy to make a mistake. High cost, loss of data, late finding of data, huge volumes, irrelevant, redundant. It's sort of almost like, exponentially we've found the copy machine and what the copy machine did to discovery in the 60s and 70s and 80s. So the amendments with starting at the first few of them have to do with Rules 16 and 26, pretrial order, initial disclosures, and the discovery meeting or the initial discovery plan. And the idea was that an ounce of prevention is worth a pound of cure. If we could start dealing with electronic or e-discovery issues right from the very beginning, and maybe get a judge involved, get the parties talking, and trying to figure out how they're going to go about this, then we would stave off many problems later on in the case and also help save clients a lot of money. So one of the things to begin with is that you deal with e-data as a separate item in the scheduling orders right from the beginning. 26A for the initial disclosures, the mandatory disclosures. This is a required disclosure. So again, you don't have to ask for it. You have to start right from the beginning, giving up electronically stored information that your client has that may be relevant to a claim or defense or its support. The 26F discovery plan or the discovery meeting, to come up with a discovery plan, you have to discuss e-discovery as a separate item. So those are key parts. 16B, the scheduling order. The parties are required now to include ESI in their initial disclosures, and they're required to discuss and preservation and disclosure of the ESI. Usually this means let's get together, let's agree on a vendor that may be scanning or digitizing this information. Are we going to use native file formats, or are we going to change everything over to PDF and then look at each other's PDFs? All of those are important issues which we will discuss. So parties are supposed to agree on discovery procedures. Form 35 deals with that. And agreements will include any number of kind of discovery issues discussing electronically stored information. So again, we're running through it quickly. We don't have much time, but the point is that to take from this is that when you start out your case, make sure that electronic discovery is one of the first things on the list that you're dealing with. Now, Rule 33, dealing with interrogatories. It's still an option to produce records in answer to an interrogatory, so you could do the same thing, of course, produce electronic data for the party. Rule 34, as you would imagine, is a big area that has been changed. E-data is complicated as a form of production, and the reason that you want to start handling this issue is to avoid the game playing, the burden, and the expense that is involved. Often, if you don't agree on which form to produce it in, you should produce it in the form in which it is kept. But you have to watch out for inadvertence, which we'll discuss in a moment. So, don't play around with the meaning of the electronic document. It used to be some people would say, oh, this is not a document because we never printed it out to paper. It's just electronically stored bits of information. That's not the case. So anything that's created or stored on a computer, writings, drawings, graphs, charts, photos, sound recordings, images, and really the big catch-all, other data or data compilations stored in any medium that can be translated into a reasonably usable form. So, data, email and instant messages, sort of the things that we were talking about before. Voicemail stored on databases, cellular phones, all of that kind of stuff is part of your electronically stored information, which can be asked for, and you have to be vigilant with your client to produce that information. It is discoverable, electronically stored information. It can be specified by the requesting party in a request, or thereafter by a responding party in a response, but again, produced in the form in which it is ordinarily maintained. There's just two more issues I want to talk about. Rule 29, the clawback provision, which goes to inadvertent production. If you accidentally produce something, you could get it back. And then also Rule 37, the sanctions. There's a safe harbor provision in there where if during this period, if we haven't if you produce something inadvertently or you don't produce something correctly the first time, that sort of thing, the sanctions may not be mandatory necessarily.